Liston. I'll skip him for now. Hebner,
Here.
Jenkins, King,
Here, and I apologize if I have to step out in a little while, but I am here.
and Simpson.
Here.
And we are still waiting for Commissioner Carrion. We hope for her to join shortly, and then at that point, we should be able to establish a quorum.
Carrillo's here.
Thank you.
What's that?
First agenda item is approval of the minutes. Are there any corrections or additions to the minutes?
I move adoption of the minutes.
Motion to approve. Second. You need a roll call?
Yes. So, Rio,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
and Simpson.
Aye. Thank you.
Director, will you handle the next several
Items clustered under administrative.
Sure. As everybody can see, we have a pretty full agenda today. In addition to, we have some panelists here today. There may be public comment via Zoom and in person. So we will also fit that in. I wanted to start by thanking Commissioner Jenkins for all her help at Legislative Council and her staff at the Legislative Data Center with our IT migration. We still have a few things to work on with that, but Commissioner Jenkins, your staff was tremendously helpful with this time-consuming and adventurous migration of our emails. And just very briefly, we do continue to monitor the budget situation. The May revise should be coming out shortly, and we will continue to keep the commission advised. And then finally, I wanted to note that we did receive a couple of public comments late yesterday. One was just to add a couple signatures to a previous public comment, but new public comment from Liberation and Generation was received. We will be posting that information to our website after the meeting. Okay, and so any questions? The next item on our agenda is commissioner suggestions.
Let's jump ahead of that while we still
Okay.
have Commissioner King and do memo 2411.
Okay, we can do that. So memo 2411 is an update on the Open Meetings Act as well as the meeting schedule. So as you all will recall, we've had a few memos discussing changes to the Bagley-Keene Act and the implications for the commission's ability to conduct meetings via teleconference. There was a question about the term of advisory body and whether that encompassed the commission. Recently, the California Department of Justice updated its Bagley-Keene Open Meetings Act guide to reflect the changes that became effective January 1, 2024. You can see in the memorandum an excerpt from the DOJ's guidance. And in a nutshell, the DOJ's guide indicates that the teleconference rules apply to an advisory body created by statute. The staff believes that this appears to apply to the commission as it is a body created by statute that makes recommendations to the legislature. Prior to the update to the DOJ's guide, we had reached out to a few executive directors of commissions similar to the California Law Revision Commission, and they also had a view that is consistent with the California Department of Justice. And then finally, again, I need to thank Commissioner Jenkins for providing us informal oral advice on the issue, and the Legislative Council did conclude that the commission is a advisory body for the purposes of the teleconferencing rules. So in light of the question before the commission, and we'll need a vote on this, is in light of the DOJ's recent guidance and the other issues that I just mentioned, does the commission wish to amend its handbook to make it clear that the commission views itself as an advisory body for the purposes of the teleconferencing authority provided by Government Code Section 11123.5 until that section is repealed effective January 1, 2026.
Thank you. Are there any questions or comments from commissioners?
I move the
Just one-
amendment.
Second.
Is there any comment from members of the public on that issue? Hearing none, there's been a motion and a second. Would you call the roll?
Yes. Carrillo,
Aye.
Commissioner Carrion is still not here. Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
and Simpson.
Aye.
Thank you.
Okay, then
You proceed.
Okay, moving on to the next issue in this memo is a meeting schedule update. So now that we've clarified the commission's authority to hold the meetings via the special teleconferencing rules, we wanted to discuss the upcoming meeting agenda with a few proposals, and we want to get the commissioner's views on these issues. So we do have, we had hoped to have the June 20th and August 15th meetings in Silicon Valley and Los Angeles. We are finding it logistically difficult and costly to meet outside of Sacramento. So we are proposing to move those meetings to Sacramento. We also they would be all-day meetings, like today's format. Then another thing for the commission to consider is we do have the teleconferencing option now, but the commission may, as an alternative, consider whether we should just move to in-person meetings for the remainder of the year. The staff has identified 2 meetings that could be canceled, that those additional in-person meetings would be all-day meetings like with today's format. We suggest that December 12th and the November 7th meetings could be canceled. And we could go forth with the other meetings. I think one thing the commissioners may want to keep in mind is that we are receiving a lot of public attention for our antitrust study and our equal rights amendment studies. They are turning out to be fairly high profile. So that might be another reason for the commission to consider moving to in-person meetings. If the benefit of having the teleconferencing option is if a commissioner cannot attend in person, they would have the option of attending by teleconference. So the question on the table is, are the proposed changes acceptable to the commission, including moving to the in-person meetings? And now I will turn it back to the chair because I'm sure he has something to say about this.
Well, I do. So that there's no misunderstanding, I've asked the executive director to look at our schedule and determine if we really need all of these meetings. I hate to sound like the old guy on the dais, but when I chaired the commission for Governor Davis and then for Governor Schwarzenegger, we met quarterly for 2 days. They were very productive. They were very well attended. I think this short monthly meeting thing has posed a problem with workflow, including with workflow for staff who are constantly preparing for low value meetings. I'd rather they have more time to prepare for high value meetings. So the question is, are commissioners comfortable taking 2 of the remaining meetings off the schedule? A second issue, which I am agnostic on, is the proposal from staff to move the 2 in-person meetings to Sacramento. And with that, are there commissioners with views to express on either of those two issues?
I'm in agreement with that.
Okay, Commissioner Simpson?
Yeah, same here. I mean, since I live in Sacramento,
Makes it
it
easy.
does make it easier. But I think longer time between higher value meetings makes sense to me.
Great. Do we need a vote on this?
With the chair's permission.
Oh, jump in, Commissioner.
Thank you, sir. I also concur, quarterly full-day meetings would be better. I would suggest that we simply adopt a running policy of making all meetings hybrid, that we make the default a physical meeting in Sacramento with a teleconference option.
So just to clarify, sorry, I'm getting used to the mic. Just to clarify, it sounds like your suggestion is that we could continue to list the meetings as in person, but there would also be a teleconference option?
Right, or if it's easier, just list all meetings as hybrid. Because there's
Okay.
almost always somebody who needs to dial in, probably me.
Given the vote we've taken on amending the handbook, I think either way of framing it gets us to the proper place.
Right, agreed.
So why don't we let staff work out the linguistics?
Okay,
Do you need a vote on what we've just done?
why don't we just go ahead and do it, because we are making significant changes to the
Okay.
schedule. So, Carrillo,
Aye.
Oh, wait, the motion would be to remove the September and November meetings from this year's schedule.
Still
And
aye.
to list all of the meetings as hybrid with staff to determine when there should be a physical footprint driven by the needs of our projects. Because we will want to see other working groups on antitrust, I think, in this kind of environment, wouldn't you think?
yes, I agree, and the staff strong recommendation is that next to the extent possible, if commissioners can attend those
In Sacramento.
in Sacramento, in person, because at those two meetings, we will be having our remaining expert reports presented.
Yes,
And we think that it's really important to have that public access to commissioners.
very good. So 3 parts to the motion: eliminate September, November. Number 2, move June and August to Sacramento. Number 3, make the rest, the full schedule for the rest of the year hybrid, but with a physical footprint somewhere. meaning
Yes.
Here.
Yes,
Is there a second?
Second.
Okay,
okay, Carrillo,
Still aye, and I'll note for the record that I won't be able to attend the June meeting.
Hebner,
aye.
Jenkins,
Aye.
King. And who was
Oh,
absent.
he's,
We
had to go.
we can go back to him. And Simpson. And it looks like Commissioner Carrion still has not arrived, so we can go back to her when she arrives.
very good. And I know we have a special order item at 10:15. I apologize, we're a couple minutes late. Why don't we pivot to that, and then you can come back to legislative suggestions
Sure.
afterward.
Okay, so today we do have a special order of business. We would like to thank our experts for being here today. First up, we have the report on concentration in California. We do have some experts in person. We do have some experts attending via Zoom. After that, we will have our expert report on single firm conduct. And again, we thank the experts for being here, both in person and via Zoom. As I indicated earlier, we do have a lot to go through with this agenda item. We anticipate that after we get through the expert reports that we would break for lunch. We come back with the opportunity for the commission to ask any additional questions. We do have some invited guest speakers who will be on a panel, both, I think, via Zoom and in person. There will be an opportunity, to the extent that they're commenting on the expert reports, for our experts to respond, as well as for the commissioners to ask questions. And of course, at the end, we will want to take general public comment via Zoom and over in person if you are here. And with that, if the chair is ready, why don't we hand it over to our panel? And let me just check with our technical person. Kristen, are we ready to go? So if you can bear with us for a minute, we're trying to get everything up and running.
This is actually going to be projected to the Zoom audience as well. If the attendees via Zoom can confirm that, it's also up on the screen for
Can the attendees via Zoom, our experts attending via Zoom, and maybe Commissioner Carrillo, can you confirm that you can see the PowerPoint presentation?
Yes, confirmed.
I
Yes.
see it.
Excellent. Okay, with that, I will turn it over to our concentration in California presentation. If you would like to start with a round of introductions, that would be very much appreciated. Thank you.
Absolutely. Absolutely. Thank you very much. I am Diana Moss. I am a vice president and director of competition policy at the Progressive Policy Institute in Washington, D.C. I am a member of our committee, Group 7, Focus on Concentration and Competition in California, a focus on critical sectors in labor markets. It is an absolute honor and pleasure to be serving in this capacity. And my thanks to our very collegial expert group who worked many hours to produce a report for the commission. And we're very pleased to be here today to give you the overview of our approach, our methodology, our analysis, and some of our findings. So if we could advance to the next slide, that would be great.
And if we could have the remaining experts identify themselves for the record. Thank you.
Good morning. I'm Dean Harvey. I'm a partner at Leif Cabraser, Hyman and Bernstein, and I represent consumers, workers, small businesses, and unions in antitrust litigation.
Good morning. I'm Shanna Scarlett from Hoggins Berman, the managing partner of their Bay Area office. My sole focus is antitrust law, and largely my specialty is indirect purchaser actions, which mean I litigate under California law, although often in federal court because of the Class Action Fairness Act, which removed most state actions to federal court when a class is involved. But I'm very familiar with California law, and it's simply a pleasure to be able to address you here today.
And I'm not sure if we have Barack Richmond.
Hi, this is
attending
Barack
via
Richmond.
Zoom.
Can you hear me okay? Hi, this is Barack Richmond. It's a pleasure to be here. I am the Catherine T. Bartlett Professor of Law at Duke, and as of this July, I'll be the Alexander Hamilton Professor of Law at George Washington University, where my areas of expertise include healthcare policy and antitrust policy. And finally, I am a very proud graduate of the University of California at Berkeley.
Okay, with that, Diana, we will turn it back to you. I think you were going to lead it off. Thank you.
Yes, thank you. If we could get the next slide. So Group 7's report on concentration in California is really broken into 6 parts. I'll give you a brief introduction of how we approached our analysis and deliberations. We'll then move on to a presentation from Dean Harvey on labor, then on to food and ag from Shanna Scarlett, then on to healthcare and pharmaceuticals from Barack Richmond. I will dip back in with an overview of what's going on in entertainment, and then we will have a brief summary and obviously take questions. Next slide. And the next slide. Thank you. So why is competition vital in California? Good question and very important answers, both for California and for competition in general. Competitive markets, a market-based economy, is a gift and a privilege for both consumers, for workers, for small businesses and entrepreneurial freedoms. But competition must work well to promote all of the benefits of competition in terms of fair prices, high quality products, innovation, and choice, importantly, choice, but also non-competition goals. Well-working competitive markets produce a lot of very positive byproducts in the form of, for example, diversity in the media, fewer wealth and income inequality gaps between different segments of the economy. The security of supply chains, for example, is tightly related to competition in markets. So not only does competition benefit consumers, workers, and businesses, but it promotes non-competition goals as well. And California has obviously plays a vital role in the U.S. economy, in the global economy, and within the state. It is the largest sub-economy in the world, with an almost $4 trillion gross state product in 2022. California, competition in California affects California directly through smaller local regional markets, for example, in construction and agriculture and in healthcare. But California is an incredible trading partner with other states in the U.S. and certainly globally. Competition and fostering fair and competitive markets plays a key role in attracting business to locate in California, and also labor to locate in California to take advantage of very rich opportunities for labor mobility and job growth. So we took a really hard look at all of these very dynamic, vibrant sectors in California. We obviously couldn't cover them all, so we had to make some hard decisions about what to cover. And so we looked at a number of metrics: gross state product, the potential for employment in a sector, job growth in sectors in California. And we found that a few sectors had an outsized impact. And those were the sectors that I listed on the overview slide. So focusing in on these sectors is what we'll talk about in our presentation. But certainly our findings and the implications of promoting competition in California, reducing concentration, promoting level playing fields for market entry and market access and innovation, really are going to have an outsized impact on the California economy. Next slide, please. So why are we worried about this? Well, in the last, I would say, 5 to 10 years, there has been a surge of concern about declining competition in the U.S. economy. It is backed up by hard empirical evidence and studies by economists, public policy experts, technical experts. So this is not a lot of hand waving. This concern about declining competition is certainly real. And it is a big enough concern to be what we would call a public policy concern, meaning it rises to the level that we're going to need multiple policy tools to address promoting competition through antitrust enforcement, through labor policy and laws, through intellectual property laws, trade policy, all sorts of policy tools to work together to get behind and support promoting competition in our markets. So some major indicators that consolidation over the last few decades has driven adverse incomes for consumers, workers, and smaller businesses is rising market concentration. We know that in some markets, we have seen higher prices as a result of rising concentration, lower wages, fewer benefits, higher markups between price and cost. We have also seen slower rates of market entry. Again, this is backed up by empirical studies, resulting from very high barriers to entry for small firms to get into markets. Scaling those big barriers is difficult. And small business is the lifeblood of the US economy and plays a vital role in generating growth and innovation in California's economy. We want small business to drive growth and innovation. But if small business can't get in because there are dominant market players or tight oligopolies of players, then we should care about that, and we should craft a policy response to deal with that. Third, growing income and inequality gaps, which are really evident in these gaps between the most profitable firms and the least profitable firms. So just a few examples of what we're seeing in terms of hard evidence that rising concentration, declining competition is a public policy concern. Next slide, please. So what are the policy responses? Well, right here, right now, before the CLRC, we are talking about a very important policy response. But there are many. Again, this is a multi-pronged toolkit that we should be tapping into. We have had an intensification of public and private antitrust enforcement. Federal and state enforcers have intensified their efforts. The California Attorney General obviously plays a key role in all of this, as do other states that have really expert, rich resources in antitrust economics and law and policy. Private enforcement plays a really key role in as a complement to public enforcement in the U.S. in obtaining restitution for victims of antitrust violations. So we have seen a ramping up and a focus from both public and private enforcers to enforce our antitrust laws in the United States and in specific states for the benefit of consumers and workers. Legislative responses and what I'll call soft policy responses. There are many types of responses. Revisiting state level antitrust statutes, as you are doing in California, as New York has done as well, and as has been proposed in other states. The DOJ and the FTC just issued revised merger guidelines, which are designed to invigorate enforcement and provide more guidance for the business community, for the courts, for judges, for the consumer community. And they are also undertaking a revision of the Hart-Scott-Rodino merger filing requirements as well. So these policy responses, hard policy responses, soft policy, legislative, antitrust enforcement, are all really designed to work together to advance the critical goal of promoting competition in our markets, and especially in this context, California's markets, for the benefit of consumers, small businesses, workers, and frankly, to support the democratic values that markets rest on and that are so vital in our political economy. And with that, I will pass it on to Dean Harvey to discuss labor markets. Thank you.
Good morning. Thank you for the opportunity to address you today on these important issues. For a long time, competition law concerned itself almost exclusively with consumer welfare and the prices of products, and asked, are products priced competitively? Are there choices for consumers? These, of course, are critical questions. But this ignores that citizens are more than consumers of products. They're also workers, and that people cannot afford to buy products unless they're paid competitively, unless they have job mobility that allows them to choose meaningfully where to work and to obtain a competitive wage for the work they provide. Despite the critical importance of labor to the economy, competition law has largely ignored labor until the past 15 years or so. And so it's only in the past 15 years have courts started to grapple with the application of competition law to labor markets. And as I'm sure you all know, antitrust law is a little bit unusual in that it is almost entirely common law judge-made. The relevant statutes, the Cartwright Act in California, the Sherman Act federally, state broad principles, but courts have created all the doctrines that provide rights of action, provide defenses, and so forth. And while the Cartwright Act, of course, is its own statute, both state and federal courts largely defer to federal courts unless there is clear legislative action telling them to treat the Cartwright Act differently. Next slide, please. So what's going on in labor markets from a competition standpoint? There's a well-known and well-documented trend that began in about 1979, where the productivity of workers has not resulted in a commensurate increase in their wages. That is, people are working harder, they're working longer hours, they're being more productive, but they're not being paid in a way that is commensurate, that is proportional to the added value they're creating in the economy. Since 1979, the average worker productivity has increased by about 65%, but their pay in real terms has increased by just about 15%. Of course, increasing wages are critical to the standard of living and quality of life of anyone. And I would say that, to state the obvious, perhaps this is particularly important, I think, in California, as California citizens cope with rising inflation and housing costs and homelessness. Being able to find a job and being paid competitively is a critical and urgent issue for the state.
I'm sorry for interrupting, but just so commissioners are clear and don't forget to come back to it, would you define what's the measure of productivity that's used on the chart? I understand wages because that's dollars, but what's the productivity measure?
This is the value of the products created throughout the economy, essentially. So it's an indirect measure. It's not a direct measure of taking a survey, for example, asking employers to give an estimate of the productivity of their employees. It's trying to infer productivity from the general production measures and profitability of firms. Next slide, please. So our group was asked to think about concentration, which I think is another way to think about, another way to frame an issue of, do employers in the labor context have an excessive amount of market power? What are the trends there? How do those markets work? And here there's been quite a bit of movement in recent decades among labor economists, and antitrust law is still keeping up and trying to sort of figure out how to apply findings of labor economists. Primarily, for a long time, labor economists and economists, generally policymakers, assumed that labor markets were pretty competitive. And one example of the implications of that belief is that you shouldn't increase the minimum wage. Because if you increase the minimum wage, that will force employers to either pay employees more than the value they're creating or fire them. And of course, no rational employer would choose to pay a worker more than the value they're getting, and so it would result in unemployment. You should never increase the minimum wage. A path-breaking study conducted in part by David Card at the University of California, Berkeley, which in large part earned him the Nobel Prize, found that even if you look at the least skilled, lowest paid workers in the economy, that is workers working at minimum wage, those employers enjoy a substantial share of the value being created that they retain for themselves, and do not pay their employees what economists would describe as their marginal product. And so, of course, there are limits to this, but when you increase the minimum wage, it does not necessarily result in increased unemployment. It simply results in the employer providing the worker a larger share of the value that the worker is creating. The question of market power in the antitrust context has been developed in the context of products. In labor, though, it's a different situation, and labor is fundamentally different than product markets. Really, any employer enjoys a significant amount of market power over their employees. when you ask about market power, it's basically asking, does a seller of a product or a company who hires employees, do they have the ability to pay less than the competitive wage or charge more than the competitive amount without losing customers in the context of products or losing all their employees in the context of employment? And many studies have shown, this has been led in part by economists like Alan Manning at the London School of Economics, that if you reduce the wage of your employees, they do not all instantly quit and find a comparable job in the economy. And that is because the interaction, the economic transaction there is significantly sticky, to use a jargon term from economics. And we know that in our own common sense, real world experience, that choosing a job, being hired, is not akin to choosing between brands of breakfast cereal in the grocery store, where you can have Captain Crunch one day, Fruity Pebbles the next. You respond in real time to 2-for-1 sales on Tuesday and so forth. The employment transaction is a relationship, and it's one characterized by matching, where it doesn't occur unless both the employee wants to work at a firm and the employer wants to hire the employee. There are tremendous search costs involved of trying to find an employer, putting your resume together, taking time off of your job to interview. There's also tremendous amounts of uncertainty. The employee has no idea if the employer is a good place to work, if she's going to be sexually harassed by her supervisor. The employer doesn't know if the employee is going to show up on time. They both take a lot of risks, and they agree to create this relationship, this employment relationship, which is something like a family relationship. And a lot of employers characterize their workers that way. We're a family, and there's a reason for that. An interesting study asked people throughout the economy to measure and rank the most stressful events in their lives. Events such as the death of a spouse, the death of a close family member, the death of a close friend. Losing your job is ranked higher than the death of a close friend. It's a traumatic event. And once that economic relationship is formed, it's sticky. Of course, employees can quit, and they do. Employers can terminate employees, and they do. But once that is formed, there are tremendous frictions and power that the employer has to, over time, pay the employee less than the value they are creating. And labor is often the largest cost that companies face. And this is, I think, particularly true for markets that are important in California, such as the information technology companies, the entertainment industry. Paying workers is very often the single largest cost that firms face, and it's enormous. And so employers and companies, like any other major cost, have significant incentives to do what they can to save those costs and to pay less than what they might otherwise pay. And it is only the forces of competition, the threat of losing the employee to a competing employer, that will provide the incentives for an employer to pay their employees at rates that are more commensurate with the value they are obtaining from those employees. Next slide, please. There are a few areas of concern, and in the past 15 years, I mentioned that's really the only time that courts and antitrust regulators and enforcers have really focused on labor, and these have been the items that have come up. The first, this is probably the most well-known, and it's really what started this modern trend, are agreements among rival employers not to compete for each other's employees. Sometimes these are referred to as no-poach agreements. The most well-known example of this were agreements among the leading high-tech firms in Silicon Valley not to actively recruit each other's workers. These companies included Google, Apple, Intel, and other very high-profile companies. Another example are non-compete agreements between employers and employees. Here, these are not, like the first category, these are agreements between employers that are largely secret and not disclosed to the employees. There's a critical distinction here between that and this category, where these are agreements that employers enter into with their employees. So the employees are aware of them, typically in the employment contracts, that contain provisions like you cannot work for a company that does the same thing we do, defined in some way for a certain amount of time within a certain geographic distance. Until recently, this was governed by a patchwork of state law that was outside of the ambit of competition and antitrust. Of course, California has been the leader in this regard for a long time, where non-compete agreements are generally unlawful in California. And there have been recent steps that I think have been very important to enforce that, such as requiring employers who may have put unenforceable non-compete agreements in their employment contracts in California to inform them that that is not enforceable and to remove them from those contracts. I know personally people who work in tech in the state who received those letters, and it made a big difference. There's a lot of wonderful work going on there in California, and I applaud it. Nationally, the Federal Trade Commission recently, just last week, I believe, voted in favor of essentially adopting the California rule nationwide. That was immediately challenged by business groups, and there's litigation pending. The rule has not yet taken effect, and we'll see what happens in the courts. Another category is mandatory arbitration in employment agreements. Trying to vindicate your rights as an employee by filing a case is tremendously expensive. And if you're subject to mandatory arbitration, it essentially never happens. And if it does, I'm not aware of a single example of it ever happening. But if it did in fact happen, any resolution there would largely remain secret and would not benefit anyone other than the individual seeking arbitration. Next category are mergers that consolidate labor markets and increase employer concentration. As Diana mentioned, the two organizations nationwide that generally take the lead on merger enforcement, the United States Department of Justice and the Federal Trade Commission, periodically issue merger guidelines. And the most recent update was released just last December. And in that document, for the first time, the guidelines expressly mention labor concentration as an issue they will consider in evaluating mergers. So to give you a sense of how new this is for the competition community, it's the first time that this issue has ever been expressly included in the merger guidelines, and it's just a matter of a few months ago. The last category is really outside of the ambit of competition, but I think it's important, is the misclassification of workers as independent contractors, such as the gig economy. Doing so, of course, removes a lot of rights that employees have to collectively bargain and so forth, and provide more market power to employers. Yes, please.
Just a quick question. When you say consolidate labor markets and police employees, what exactly does that mean?
So for example, until very recently, a proposed merger such as, say, a merger between two telephone companies, the agencies would approach that from the standpoint of what will this do to consumer welfare, to product prices and product quality.
Right.
They generally would not, I don't think it would occur to them until recently to ask, well, what about the workers? There are skilled workers at these two companies, and if you merge, of course, this is there's a certain tension here, and antitrust scholars and enforcers have been trying to work all this out, where what has been previously thought of as an efficiency, a benefit of a merger is that, we'll be able to lay off a bunch of people and we'll be able to be more efficient. In the past, that has generally been viewed favorably by government agencies reviewing a merger as an efficiency. With this new guidance, it presents a little bit of a tension. Is that viewed favorably because the firms are more efficient, or is it unfavorable because it could result in many people losing their jobs? And if you look broader to say a set of skills that may be, a specialized set of skills for engineers at these firms, does that significantly reduce the alternative employment options available to those workers? The agencies are now asking questions like that. And this is, I think, in some ways, one of the cutting edges of antitrust enforcement is trying to work out those trade-offs. Next slide, please. And so where do we go from here? I would say that in the recent 15 years of experience, there have been some successes and some challenges. And I will hit on, I think, some of the most important issue here. If I had to pick one issue, it would be market definition. And here, I think of it as kind of a fallacy of market definition, that the term appears nowhere in the Sherman Act, it appears nowhere in statutes, but courts have often required those injured by anti-competitive conduct to define a relevant market in some precise way. And then courts will say, well, market power couldn't possibly exist. Competitive harm couldn't possibly happen unless the companies accused of misconduct have some large share of that market. That approach is a fallacy because it is using a proxy for a different question as the only relevant question to ask. The question is there market power? Has there been competitive harm? How do we figure that out? The best way to do it is to figure it out directly. You get data, you look at the evidence, you see, did companies actually increase prices without increasing quality? Were employers able to reduce pay for workers because they had an agreement with their labor competitors not to compete for each other's employees? And that is the relevant inquiry. Market definition and market shares really can be appropriate only in a situation where that data is not available to you. It doesn't exist. And so you're forced, regrettably, to look at a proxy for that. This can sometimes be necessary or helpful in the merger context where you're not looking at something that's already happened. You're trying to forecast and predict what will happen in the future if you allow two companies to merge. And there, because you don't have data in the future that doesn't exist, sometimes that type of proxy might be effective. But otherwise, it gets in the way. And this has been particularly inappropriate in, I think, the labor context where, take, for example, the case I mentioned before about agreements between high-tech firms, Google, Apple, not to recruit each other's workers. The court there certified a class of about 68,000 workers throughout the country that included very different skills. Within that same class were storyboard artists at Pixar and semiconductor engineers at Intel. Those skills are not substitutable with each other. It doesn't really fit into a market definition framework, but the data showed clearly that there was harm there. I think in the labor context, my sense is that it's an example of sort of antitrust courts and litigants using the antitrust hammer, looking for antitrust nails, where it's just not the right approach in employment markets. And I think competition policymakers can learn a lot from those who have been looking at employment markets for a long time. For example, you think of race discrimination, gender discrimination cases. Imagine a situation where it has been shown that an employer has an expressly discriminatory practice. You go into the break room of the C-suite, there's a sign on the wall that says, pay women 10% less who do the same work as men. And you look at the data, and the women are paid 10% less. That is a slam dunk case in the employment context, or for a government enforcer looking at that situation, there's obvious harm there. In the antitrust context, an antitrust court might say, wait a second, there could not possibly be harm. I don't want to look at the data until you first define a relevant market. What company are we talking about here? Are they a company where there are many companies that do the same thing? Well, if that's the case, markets are generally competitive. And if you're paying women less, they would instantly know that. They would quit, and they would find a comparable job at a competing employer and be paid the non-discriminatory wage. So there couldn't be any harm here. Case dismissed. That's how things are going in the antitrust context as applied to labor. It, I think, strikes those who are familiar with employment as absurd, but that is essentially what some courts are doing. And in the no-poach context, where there has been a lot of attempts of government enforcement in the criminal context, the United States Department of Justice has pursued criminal cases prosecuting no-poach agreements. And the courts there, I think it's fair to say, have struggled with this and have, in different ways, incorrectly applied a kind of market definition requirement on the government. And so even though the agreements clearly happened, the misconduct clearly happened, the criminal investigations and enforcement efforts have failed. And so I think here, it's a problem that I think is critically important and I think cries out for a legislative solution. And with that, I'm done. Thank you.
Good morning, Shanna Scarlett from Hoggins Berman, and I'm going to be discussing consolidation in the food and agricultural markets. Can you go to the next slide? And the next one after that. So as passionate as my colleague, Mr. Harvey, was about the labor markets, and I certainly agree with him. I think I heard him refer a little bit derogatorily to food on consumers' plates and to cereal. And I think it's my job here today to convince you all that consolidation in the food and agricultural industries are one of the greatest threats to California and to consumers. And I want to start with a question one of the commissioners just asked, talking about consolidation in labor markets. And I'm going to tell an anecdote that I think explains why consolidation can hurt both sides of the markets. That is, there's not either harm to workers or harm to consumers, but in fact, consolidation harms both. I'm one of the counsel in the broilers antitrust case, a case that's been litigated now over the last 8 years. Department of Justice has tried three criminal trials of executives of the broilers companies for price fixing and bid rigging. All three of those were met with failure. And despite knowing that it is actually true that this behavior happened, because one of the companies pled guilty and paid over $100 million fine, Department of Justice has been unable to truly get justice on behalf of the US government. So the broilers market is a very consolidated market. We put statistics in our report, and I can get to them later. But chicken processing is run by very few companies. And these companies, because there's so few of them, become very familiar with each other. They have a company called AgriStats, which shares a lot of statistics across them. We see a lot of meetings. What happened in the broilers market was these companies got together and fixed the price of chicken being sold to consumers. I represent the California class. We're going to trial in September. There's an enormous amount of harm that's been done to California consumers. I asked my experts last night for the number of damages that'll be at issue in the September trial. And the number that they gave me for California alone is estimated damages of $668 million. But the other side of this consolidated market, besides this harm to consumers who are just buying chicken at grocery stores, is what happened in the labor markets for those employees that are working at the processing plants. During our litigation of the case, we also had an investigation that came across a set of collusive meetings by these same poultry processors. So as they were fixing the price of chicken, they were also sending their HR executives to Sandestin, Florida, and other very, I would say, resort-like hotels. And they would meet once a year, and they would have a roundtable discussion, and they would ask the person who was doing the survey to leave the room, and they would then set what the wages and benefits were going to be for the next year for the workers. And the palpable injustice here, where these are some of the most vulnerable workers in California. To be clear, there are processing plants in California, but also nationwide, where these workers perform some of the most dangerous work. They're on lines where the chickens are moving through quickly. They are slicing their necks, cutting off heads, cutting off feet. One of our named plaintiffs is a grandmother, and her hand is in a claw from the repetitive strain injury of taking this type of work. On average, these workers are making $14 an hour. These are not incredibly lucrative jobs, and yet they're incredibly dangerous. But consolidation in the processing arena allowed these companies to both raise the price to consumers and at the same time suppress the wages of their workers, the most vulnerable workers. And it's really astounding when you look at the full scope of evidence of what can happen from consolidated markets. Turning to the consumer's plate in California, food is a necessary good. It's one consumers can't not buy. It's necessary for survival. It's necessary for the health of California residents. And that's why it makes this issue one that should be of heightened importance to California's legislature. 4 meats dominate consumer plates: beef, pork, turkey, and chicken. And the impact to all California consumers from overcharges that can attach to this type of necessary item is enormous. In California, a family spends on average $662 more per year than the national average. And there's a lot of reasons for this type of overcharge, but one is clear. Next slide. The consolidation of the food distribution chain. There's a lot of issues as we look at this chart, but I want to just focus on those red boxes. Those red boxes are a juggernaut to get from a live animal down to meat on a consumer's plates. That requires processing plants. And that is where we've seen over the past 20 years consolidation unlike any other industry. In beef, in 1977, the largest 4 processors controlled only 25% of the market. Today, it's 82%. In pork, in 1976, the top 4 controlled 33%. Today, it's 66%. And in chicken, 1986, the top 4 controlled 35%, and it's 54% today. So why does that matter? Next slide. Consolidation has real impacts, and it really creates a lot of risks. This is a graph that we'll be using a trial in September about chicken prices to consumers. Again, that will be California consumers. It's one of the largest parts of our class. You look how price follows costs. For the most part, there's booms, there's busts, there's costs of grain, there's variations that happen. But then you see around 2012, price, that blue line, separates from cost, that red line. The comment of the California Chamber of Commerce, which is before you, and I believe they'll be speaking this afternoon, says, in a free market, competitors increase market share and undercut rivals by slashing prices to consumers. I agree with the California Chamber of Commerce. And I would say to you, that is not what is happening in the food and agricultural industry. Next slide. This is beef. This is a pricing graph that's included in one of the complaints filed against the beef industry. You're going to see the same pattern here, but it starts in 2015. As you know, it's a different market and different things happened, but the same effect. Red is cost, blue is price to consumer. There is something not functioning about a market where you see prices of a commodity item that is so detached from the cost of that item. And it's due in large part to consolidation. Consolidation means that companies can take advantage of pandemics. They can take advantage of inflation. Prices go up and they don't come back down. And there's also the increased opportunity for collusion. I read all of the comments and the criticisms of our report. And one comment that I saw repeated throughout was that all of the ills that we're talking about can be addressed under the current laws. And that is simply not true. The playing field is tipped against consumers. I would point no further than the Department of Justice losing 3 criminal trials to chicken executives where there was an acknowledged guilty plea by one and a fine of over $100 million. The reality of what is happening in the courts is not matching the reality of what is happening in the world. Next slide. On top of a consolidation in terms of the processing and the agricultural level, consumers are also facing massive consolidation at the retail level. Grocery stores continue to merge, become larger, and the outcomes to that are a few. One, higher prices. If you're the only game in town, you can put whatever price that you want on those groceries that consumers are buying. Two, food insecurity. Mergers of grocery stores mean that the number of US grocery stores has decreased by nearly 30% from 1994 to 2019. Closing of grocery stores means that food deserts that already exist in California are becoming exacerbated. And just so you understand the true impact of food deserts, I live in Berkeley. One of my good friends lived in Emeryville. She's moved now, but while she was there, it would take her a 45-minute bus ride to get to her nearest grocery store. And that level of requiring someone to go out of their way to get to a grocery store to get healthy food means many lower income areas end up opting for inappropriate food that is more shelf stable and do not have access to the type of fresh produce and meat and protein that are necessary for a truly healthy diet. So beyond just the dollar impact of a food desert, we have an enormous, and from my perspective, not even quantifiable impact on health. And then, of course, we have labor markets, and Dean addressed that a little bit. But part of the challenge to the Kroger merger that's happening right now involves the impact on the grocery store workers. Because when you consolidate a market, you have harm on the one side to the workers, and you have harm on the other side to the consumers. I just wanted to address one comment that came in late yesterday that I think really made me frustrated. The comment of the Information Technology and Innovation Foundation suggested that markets are not more concentrated and cited to its own paper and put forward some information for you all to consider. I would say this. What they're saying in terms of consolidation and concentration is looking at such an aggregated level and not really focusing in on the harm that can happen on an individual market level, that comment is not helpful and in fact largely disregards all of the harms that we talk about in our concentration chapter. And they also cite to a 2009 GAO report and suggest it did not find concentration had adversely affected commodities or food prices. That is not today. 2009 was an unusual time of the Great Recession, and that is not what is happening today, and that is not the harms that we see today. You saw those two pricing charts where we see price and cost split apart in 2012, 2015. That very much makes that 2009 report obsolete. And I'll also just point to some statements by the US White House, which is also incredibly concerned about what is going on in America's food chain, where they say that while factors like increased consumer demand have played a role, the price increases are also driven by a lack of competition at a key bottleneck point in the meat supply chain, meat processing. But I'll leave you with the same words that my colleague Dean said about the labor market. The game is rigged. Consumers are barely able to litigate their claims in federal court, and the courts are shaping all of the conversation over what is required to state an antitrust claim. For firms like mine to bring a claim on behalf of consumers, we spend nearly a year, if not more, investigating. We retain economists, we have private investigators, we go out and we interview. There is no way a common consumer would be able to undergo this type of analysis. And then when we get to court, there are hurdles in front of us that I would offer are not faced in other areas of law. That's why I believe that action is really necessary here. And thank you for your time.
Hi, thank you very much again. I think that there is some feedback. I was hearing this from when Diana was speaking. I don't know if it's possible to mute the auditorium Zoom connection. Oh, no, then it's fine. We can go on to the next slide. Again, I'm Barak Richmond. I'm here to talk about the health sector. I'll be brief because the problem of monopoly and market concentration in the health sector is from point A to point Z throughout the health sector. I think that the health sector not only illustrates a lot of the most severe problems with market concentration, but also illustrates some of the signature policy failures that got us here. And it also illustrates some of the real policy challenges that lie ahead. We'll go on to the next slide. So Shauna said that the family of four typically spends $10,000 on food. Well, for healthcare, it's $10,000 per capita, per person. This actually is really something that has insufficiently received alarm. Healthcare spending in the United States, California included, is way out of proportion compared to the rest of the world. About more than half than the average OECD nation. The reason we're spending much more is not because we're getting better care, and it's not because we're getting more care. There has been a lot of cross-national comparisons. It's simply because our prices are higher. And this is causing real harm to both individuals, families. Out-of-pocket payments are really burdensome. Most family bankruptcies are due to healthcare costs. This has caused a lot of problems in the private sector. A lot of businesses cannot hire people because of the cost of healthcare. And it also is causing enormous strain on public budgets as well. 33% of California's budget is spent on healthcare. That's a little higher than average, but that is reflective of the national problem. And it's worth just percolating on this point for a little bit. Healthcare costs are causing private bankruptcies, are causing public financial crises. They are squeezing out all the other things we would want to spend money on food, on education, on crime prevention, on public works, on tax deductions, whatever we would want to spend our money on. Healthcare is sucking out both public and private dollars, and we're not getting healthier. So that's perhaps the most important point, and maybe the ancillary second most important point, is that it is because we're paying high prices, and it's not because of any change in quality. And I'll talk a little bit about the health insurance sector. I'll talk a little bit about the PBM sector. I'll talk a little bit about the hospital sector. It is worth emphasizing that most health insurance markets, including in California, are highly concentrated. 3 health insurers in California control 80% of all health insurance. And that's also related to PBMs, pharmaceutical benefit managers, 3 of them control 75% of all prescriptions. These are the intermediaries in the healthcare sector, and there are some other intermediaries also, but these intermediaries and the concentration thereof play outsized roles in the economic consequences of concentration. They don't just increase prices, they ossify our healthcare system. They lock us in to the bad healthcare delivery system that we're trying to innovate out of. They reinforce dominance across the delivery system. And these intermediaries really play roles that we don't fully understand, in large part because their internal budgeting is non-transparent. There's a recent Blue Ribbon report that the PBMs not only cause a lot of competition problems, but because they are so non-transparent, they really impede important values of competition or possibilities of competition. It's very hard to compete if we don't know what prices are. Next slide. So I guess there's 2 important points to emphasize regarding these intermediaries. Number one, they have gained market share through a series of acquisitions. And these acquisitions largely took place before there was a recognition of the kind of economic harm they caused. The FTC allowed a lot of mergers and a lot of acquisitions of the PBM market. Insurers also have been able to merge. In a very important counterexample, the Department of Justice challenged 2 mergers a couple years ago one between Anthem and Cigna and the other between Aetna and Humana. The mere suggestion that those insurers thought they could merge, they are 4 of the largest 5 national insurers. The mere suggestion that they thought they could merge suggests how tepid anti-merger policy really had become up until that point. I think that those challenges are the exceptions that prove the rule. And what's also really important from that experience is that because of those challenges, a lot of the insurers really had to change their business strategies to that pursued greater value. So antitrust policy not only prevented greater concentration, but really forced companies to be more competitive and seek value in ways that are better for consumers. So that's the story about mergers. The other thing that's important to talk about with regarding these intermediaries is that they evidently are engaging in a number of different business practices that not only are impeding entry into their own intermediary market, they are a concentrated market where the concentration really reinforces itself, but they also are impeding entry into other parts of the market as well. One important phenomena is that PBM concentration has prevented entry by pharmaceutical producers that might be able to challenge blockbuster drugs. The intermediaries benefit from sustaining long-term relationships with the blockbuster drugs, and part of that quid pro quo is precluding entry. You also see the same phenomena taking place between insurers and hospitals. So the concentration of all of these intermediaries pose some very severe challenges, not just to competition in that particular market, but in the entire healthcare market writ large. Next slide. This slide is a little snapshot into what these intermediaries, what the markets now look like. There are 6 PBMs nationwide. 3 of them are much larger than the other 3. 3 of them, as I mentioned, collectively constitute about 75–80% of the market. One thing that's important also to know is that those 3 PBMs are each controlled by insurers. Aetna owns CVS, Cigna owns Express Scripts, and United owns Optum. So when we're talking about these intermediaries, insurers and PBMs, we're actually in many ways talking about one intermediary. The financing and delivery of most healthcare is now happening through a very opaque but very centralized process. Next slide. And now I want to talk about hospitals. Over the last 35 years, hospital prices have increased 600%. Margins have increased. It has happened in California and it's happened nationwide. And empirical studies suggest that the reason is because of hospital mergers and hospital concentration. There are now very few places in America are now home to a competitive hospital market. And it really has brought enormous harm to patients and consumers. Prices have gone way up. Quality goes down with concentration, with lack of competition. And perhaps the most harmful element is that we now are wed to the hospitals. The hospitals and the insurance companies, the intermediaries, but especially the hospitals, they not only control the hospital market, but now many are controlling physician markets also. About 10 years ago, 3 out of every 4 physicians in America was independent, was part of an independent practice. The independence of physicians is something that our culture, our economy, our health, legal, and cultural system was dependent on. We all needed to rely on the independence and professional judgment of our physician. In less than 10–12 years, we've gone from 3/4 of physicians being independent to 1/4 of physicians being independent. Now it's actually even closer to 20%. Most of this because they now are controlled by hospitals. Hospitals now employ more than half of all physicians, and about 20% are now employed by insurance companies. The consequences of this haven't been appreciated yet, but it changes the way we get care. It changes the way we finance care, and it changes the locus of care. It has not only pushed us towards more interventionist, high cost care, but it has brought us away from preventive care. It has not freed us of pursuing innovations that have allowed physicians to really monitor chronic conditions. We are now entirely reactive, and we are not investing in future care. And unsurprisingly, this is happening throughout California. 75% of all counties are highly concentrated. In 39 counties, more than 75% of physicians are working for large corporate entities, that is either hospitals or insurers, and high concentration associated with higher prices and lower quality care. Next slide. So the next two slides, I'm going to talk about two different case studies that happened in California. Both of these case studies are illustrations of how hospital markets have become concentrated, and they are illustrations in failures of competition policy. So I'll first talk about the Sutter Hospital acquisition. This is an example of serial acquisition. Sutter is was a system that was based in Sacramento. Maybe it's still based in Sacramento ostensibly, with 2 hospitals, and it now has 24 hospitals. This was a hospital system that grew to prominence not through efficient care and not through high quality care, but simply through acquisitions. And now it dominates many markets in the state. And for those reasons, with that dominance, they have engineered a number of severely anti-competitive practices. This involves linking hospitals in networks together, bundling different kinds of care, squeezing out and foreclosing other entrants, harming the independence of physicians, and of course, increasing prices. This led a class action lawsuit under the antitrust laws that was supported by the Attorney General to lead to a settlement where Sutter agreed to end certain anti-competitive conduct. But it hasn't stopped Sutter's acquisitions. And as recently as last year, Sutter bought another physician practice in Santa Barbara. There's a little bit of a Kafkaesque story here happening where one hospital system keeps buying up others, keeps accumulating monopolistic practices and monopolistic power, is punished for it, but then continues with its acquisitions. There needs to be, I guess, much like there's value in preventive care, there is value in preventive antitrust policy. We now are in a situation where we are stuck with Sutter monopolists. This is very, very hard to unscramble these eggs. We now have a hospital system that dominates many hospital markets in the state. This is an illustration of failure to stop the acquisitions before they occurred, and the state is suffering the consequences of it. Next slide. The other example I want to talk about is in Southern California. Now, actually, it's interesting because some early analyses that really proved how damaging Sutter was were analyses that showed that the cost of healthcare was much lower in Southern California than it was in Northern California, because in Southern California, there was resistance to the consolidation wave. And maybe this slide suggests that instead of Northern California following Southern California, the opposite has happened. Cedars-Sinai recently acquired Huntington. This is not quite a serial acquisition story like the Sutter story, but this is a story of a must-have hospital. A must-have hospital is a hospital that certain insurers think they need to have inside their insurance network. And because of that perception, and because of that collective perception that a insurance product, a so-called narrow network plan, cannot succeed, the must-have hospital has exaggerated market power. And that's what happened here. Huntington felt that it could not compete with Cedars-Sinai in the market. Cedars-Sinai saw the opportunity to expand its footprint in the LA market or the Southern California market. And even though there were very significant concerns that this wasn't any competitive market, that it would increase prices, it nonetheless, under current law, enforcers were unable to stop it. There are a couple illustrations here as well. For starters, we have to figure out how to navigate, how to modulate a reasonably competitive marketplace. We have to make sure that insurance products that do not have must-have hospitals can proliferate. One reason we've had trouble doing that is because all the healthcare costs are largely hidden. When an individual gets an insurance product from an employer, they don't know how much the employer is paying. It does for sure result in lower take-home wages. And in fact, one of the more significant reasons that take-home pay has gone down is because money that is withdrawn or withheld from the employer, from the employee, has gone up to pay for insurance premiums. And this is something where states can really play a very significant role, not just in preventing these acquisitions from taking place, but coming up with a regulatory framework that encourages insurance products to develop narrow network plans. In many ways, this is the challenge that we have. There are very few markets now where there are competitive hospitals really competing with each other. Very few markets where we can just sit back and enjoy the fruits of competition. Most hospital markets are concentrated, and it's going to take some real effort, not just to prevent further concentration, but to really limit the harm that we've already caused and trying to limit the severe dysfunctions that concentrated hospital markets cause. I'll leave it at that. I'm happy to answer other questions afterwards.
Thanks, Barak. And thank you, Shauna and Dean, for those presentations. We're going to finish out here with a quick look at what's going on in the entertainment sector in California. And in the process, I really hope to draw together some threads, major themes of what you've heard coming out of the discussion of labor, food and ag, and healthcare and pharma. If we could advance to the next slide. Entertainment is a critical sector in California. Much like you've heard from the previous presentations, consumer Californians spend a lot. They spend a lot on entertainment, $3,000 a year per household in 2022. The entertainment sector furnishes enormous jobs to Californians, over 700,000 jobs in California, $70 billion in wages, $100 billion in tourism. This is a major addition to the state's economy. And what I mean by entertainment at this stage is anything involving music. For example, we have film and production. We have gaming, the burgeoning gaming sector and the digitization of various entertainment sources other than live entertainment. So we're really talking about this whole collection of ways in which consumers can avail themselves of music, of art, film, and innovation in the creative arts. I think is something that we don't perhaps appreciate as much for a free and fair and open civil society, and the ability of people to access entertainment as part of their lives. We certainly saw after the pandemic that the inability to access entertainment, whether it be at a movie theater or a live event, really took its toll on mental health, emotional health, and the general well-being of the public. So entertainment is extremely important. Can we advance to the next slide, please? As I mentioned, there are major technological innovations in play, going from traditional go to the movie theater to streaming. There are enormous shifts in how entertainment market participants earn revenues. But this is a vital and vibrant process that is accommodating technological change and sort of testing the boundaries of how consumers and smaller businesses and workers in the entertainment industry are able to do well and to function. However, There has been a tremendous amount of M&A consolidation within markets and content, in film, streaming, TV, music, and technology. And much like you've heard from the previous presenters, we are seeing effects not only in labor markets, for example, with strikes involving the Writers Guild as a result of M&A in some sections of the entertainment industry. But we're also seeing consumers paying prices for entertainment, for example, live entertainment, which is dominated by Live Nation Ticketmaster. I think most important to realize as well is that there is a vibrant set of smaller businesses, independents, for example, that compete at all segments in these entertainment supply chains. And again, the role of small business in generating growth, economic growth and expansion in the United States is enormous. So the presence of dominant firms or tight oligopolies of firms in these supply chains erects enormous barriers to entry for smaller entrants to get a foothold in the market and to flourish and to grow. So the concentration problem is there in terms of music, big three, big four, media, film. Just a small handful of firms control these sectors. And back to what Shauna really illustrated very well, and Barak in the discussion of PBMs, for example, and in our protein supply chains, we have what we call market power bottlenecks, where at the processing segment, at the aggregation segment, market intermediaries, we're seeing very, very high levels of concentration, maybe 2 firms, 3 firms, 4 firms at most. And so we have a lot of market participants producing things, whether it be cows or content or anything that goes into a supply chain. And the market power bottleneck squeezes in to create a really corrosive dynamic whereby processors, PBMs, anybody in the middle possesses both market power over the folks that they are buying things from or buying labor from. So that's your buyer power concern that Dean was talking about. But when we have high concentration in these middle markets, these intermediary markets, those firms have tremendous market power over consumers, right? And so they exercise seller market power by raising prices, reducing output, and reducing choice and innovation. So a lot of our supply chains in the US and in California are now what we call bottlenecked in terms of having very high concentration in the midstream, whereby upstream producers, artists, writers, whatever industry you want to talk about, are really at the mercy of very powerful buyers and pushing down wages, pushing down compensation. And then those firms turn around and then exercise market power downstream to the consumer. So if we could advance to the next slide, I'm sorry, can you back up one slide? There we go. I'm sorry, I had one more bullet there. So for example, Live Nation Ticketmaster, we know that to be front page news. That is a really textbook example of bottlenecking in the live events markets. A merger that took place in 2010 that took Ticketmaster with 80% market share and allowed it to vertically integrate into concert promotion, artist management, venue operations. So when you have a dominant firm like that, not only are artists being harmed because they have zero bargaining power vis-a-vis this very large and powerful company, but consumers are harmed in paying very, very high ticket fees. Right now, the rumor is DOJ will be doing something along the lines of filing a monopolization case against Live Nation Ticketmaster. We do not know if that will happen or not, but certainly when we have Taylor Swift's and Bruce Springsteen's and the string cheese incident and Pearl Jam coming forward to talk about how the exercise of market power affects the production of the creative arts and the ability of artists to flourish and the ability of consumers to meet their artists in amphitheaters and auditoriums or sports teams, that is a significant concern. Same thing for Activision, Microsoft. Now, the FTC filed to block that merger and they were not successful in enjoining it, but the concern there was control over very valuable content created by app developers. Activision's content, especially their Call of Duty franchise, would be harder to get to if Microsoft, for example, made it exclusive to its Xbox hardware or its cloud gaming subscription service. So that's another example of sort of a middle of a supply chain where getting access to important commodities, important inputs was potentially at risk. So all of the presentations we've heard today have illustrated the importance of competition, the perils of having highly concentrated markets, and adverse effects on input suppliers, on labor, on consumers, but also on squeezing out or making it difficult for the very, very important smaller businesses, the independents, to compete effectively and to promote benefits for workers and for consumers in the process. So I will leave it at that. And I believe, just in summary, if we can advance quickly to our final slide, our working group really encourages the commission to really think about the policy toolkit that can be used to address competition concerns in California. And again, as I said earlier, that includes antitrust enforcement. It includes sector regulation, labor policy, intellectual policy. The Law Review Commission is obviously focused on state legislative efforts to review the antitrust laws in the state of California. And that is really an incredibly important element in this toolkit to promote and protect competition. But as you revisit the state's antitrust laws in California, we think it's very, very important to consider from a public policy dimension the importance of competition and other tools that can be used to promote it. Thank you very much, and our group is very happy to answer any questions that you have.
Thank you all for the presentations and for the work you put in before coming to make the presentation. Very valuable and very much appreciated. I will in a moment throw the floor open to questions from other commissioners. I'd like to lead with just one though, which is I understand the selection of sectors that you looked at, but it seemed like there was one missing, which is the big tech or network platform economies, which are extremely important to the state, having largely been birthed in the state. So I'm curious why that was not included. And does the panel, given the other issues you've raised, think that we need a separate study of the antitrust dimensions of big tech and platform economies?
I thank you for the question, and I'm happy to take that. You are correct. We did not cover digital. Our understanding was that digital issues and competition issues in the digital sector would be addressed by other working groups. We also, quite frankly, faced a capacity constraint in adding group members to cover what is, as you correctly point out, a very large topic. We do think that the digital sector raises a number of issues that deserve very close study. And in fact, I would even add that we are almost at an inflection point in digital technology where the sector has grown dramatically in the last 20 years. I have done a lot of studies on the growth of the digital business ecosystems. And what we have seen is a far lower rate of merger enforcement in digital tech as compared to other sectors. This is based on DOJ, FTC enforcement data. And I think enforcers at state level and at the federal level and private enforcers are now taking it very, very seriously that competition problems certainly have cropped up, and the importance of preserving and promoting competition in digital, especially as technologies like artificial intelligence develop and machine learning. And so I think my view as a member of this committee is that a very close look at the digital sector is extremely important, especially in light of the business model, which is a growth by acquisition business model. And there is nothing wrong with growth by acquisition. Some business models expand more efficiently and more effectively that way, as opposed to building it yourself and growing organically. But at the same time, growth by acquisition does raise questions that deserve scrutiny and investigation about whether that expansion is pro-competitive and will work for the benefit of competition and consumers and workers.
Because you mentioned the acronym, I have one other question for you at this point, which is, it would seem, I was a little surprised that there wasn't mention in some of the presentations about artificial intelligence. Given where it is at the moment, or where it appears to be at the moment, it almost looks like a parlor trick. But we know the folly of considering it to be a parlor trick next week. And I was surprised there was no discussion of it. Did you consider the dimensions of artificial intelligence as it comes to antitrust regulation? Because it would seem at some point, artificial intelligence could be deployed to remove human intervention in market distortion. So it seems like it's a relevant topic now, even though the technology isn't here now. Did you discuss that? And if so, why did you all punt it?
If I could jump in on this fascinating topic. We didn't give it extensive consideration within the working group, but I'm sure we have all given it a lot of thought in our own lives and our own research. What I'll say is there are just a host of fascinating issues. One, to bring it home a bit to the kind of concentration concerns we've been talking about, is that algorithms, artificial intelligence can be used by what would otherwise be thought to be fairly unconcentrated markets to coordinate in ways that would otherwise be very difficult. So the cutting edge case here, I think, is a case now pending in Nashville. It was a nationwide case about a software company called RealPage that sold its services to leaseholders of apartment buildings. And what's alleged there is that the software company used an algorithm, artificial intelligence, to set individual rent prices and to tell landlords when not to put a unit on the market, coordinating supply across all kinds of different landlords, commercial leaseholders in a particular geographic area to increase prices. And in fact, advertised its services as, you will be able to increase prices more than you otherwise would if you set prices yourself without our help. And their software actually gave unit-specific pricing recommendations that were then difficult for the leaseholder to override, which is, I think, one of the trademarks of a conspiracy. You have to look out for people who want to cheat on the conspiracy, so you have to enforce it. That's one example where I think the use of algorithms, artificial intelligence, can exacerbate the competitive harms from concentration. One other issue, it's related, is that as artificial intelligence becomes closer to the general artificial intelligence, which depending on who you believe, could be here in 2 months or will never be here, but it'll probably be upon us pretty soon. Imagine two competing firms that tell their artificial intelligence to maximize profits. Charge the highest prices you can because I'm trying to make money. And then these artificial intelligence systems are setting prices, and the systems communicate with each other and basically agree to fix prices totally autonomously with no human intervention. Is that an agreement that violates the antitrust laws? I mean, a lot of fascinating issues. In a labor context, artificial intelligence is poised to take over all kinds of different labor sectors, putting people out of work. There will need to be all kinds of policy responses to this, competition in other ways.
Questions from commissioners? Commissioner Simpson.
Yeah, on market concentration, some of the earlier reports and presentations we've heard, and I don't know if it was the courts or the enforcers of the antitrust laws distinguished between concentration that was because a firm was more efficient or had better products or did some sort of internal behavior that made it more appealing to consumers, I guess, versus concentration because of collusion between firms in a market and keeping other competitors out. Is that something you think we should still try to distinguish between? Like I sort of wrote notes in the, in the food concentration area. Is that a result of collusion among firms? Is that a result of some firms do a better job, are more efficient? And is that simply saying concentration in and of itself is evil and has bad consequences, and we should not let it happen or undo it?
Well, if I could just give a very, very narrow answer, in the health sector, in the hospital space, and of course, it's an important one where we spend about $1 out of every $6 on healthcare. The evidence is overwhelming that there are diseconomies of scale. The larger hospital systems become, the lower quality care they have. I accept the fact that industries are different, but one that is as critical to our economy and our health as this one, the evidence is absolutely overwhelming.
Okay.
And from my perspective as a practitioner, I would say we come to it after the fire has already burned the house down, right? When we come to a case and we've done an investigation, it's because we're kind of surgically looking at the harms that have happened after the fire has happened, right? We're looking at the increased prices, the decrease in quality. And so a lot of what we see shows us that consolidation means everyone should be worried. Everyone should be concerned that these harms are going to come down the road. It's very hard in terms, I think you have to put yourself back into the merger context where it's much harder to look at the ills that might come. There's a lot of hypotheticals, and I think it makes enforcers at times reluctant to act. And I think it's why many times the courts overturn any objections to mergers, because the harms are difficult to quantify and show that they're certain. But I think what Dean and I have tried to do as two practitioners who have litigated these cases is to say the harms are very real. And in consolidated markets, we often see these true problems that were spoken of before the consolidation have actually come true.
So then how do you prevent that from taking place? Should we be looking at the merger laws or the, if there's bad effects of market concentration, and it seems the data suggests that's the case, okay, what's the therefore? What therefore? What should public policy do? And should it say you can't concentrate? What does that mean on a practical basis? For okay, we don't want that to happen in markets where there isn't that concentration now. So what would the public policy or laws or something do to prevent that?
Mm-hmm. So I certainly think looking hard at the merger area and what can be done to prevent more consolidation than we've already seen over the past 20 years. I would also say a second step could be to look at enforcing very specific statutes or conditions that would allow competition to foster, that would allow small entrants to come in. The one thing that we see in competitive markets is it's very hard to form a cartel or collude if there are many participants. And when you have a lot of smaller players that are able to move nimbly and acquire market share, steal customers, compete on price, those are healthy and competitive markets. So looking really hard at enacting statutes that would allow and protect those small entrants or the existing participants. And then a third kind of way that you can get at this problem, because in some ways there are heavily consolidated markets that are a problem, is to look really hard at what California can do to allow access to justice, to allow consumers and workers that are not rich, that have, small dollar value at stake at times, right? Claims and class actions can be $30, to allow equal access to justice, to put laws into effect protecting California consumers that would allow them to bring complaints, that would let them survive motions to dismiss without having what is now required, which is really a person in the room. When I was speaking earlier about how much money it takes my firm to bring one of these cases, and when we do those investigations, what we come up with are what we called CWs, confidential witnesses, and our complaints contain statements from confidential witnesses saying, I knew of that meeting, I attended that meeting, I heard what they said, or I was a guy in the room. And at this point in jurisprudence, that's one of the only ways that antitrust complaints can get through motions to dismiss in federal court. And I think it's really important for that critical access to justice and being able to bring claims is to look at this third leg as well and look at how difficult it is to litigate on behalf of California consumers and to put into place certain safeguards.
Okay. Last question. I'm having a hard time distinguishing between the macro and micro. That is, on a macro sense, I can understand how concentration in the market ends up having these, bad outcomes of prices and quality and effects on labor and things like that. The actions prior to that are at the micro level. It'll be two companies that may merge or another a firm buys out another company. Those are sort of at the micro level. Is there some sort of guideline for how one would manage or oversee the micro decisions so that at the macro level you don't have these ultimately bad consequences from concentrated markets?
I would make a couple of suggestions. One, sort of what you can do before the fact, before harm occurs, and then what you can do after the fact to both address harm that has already occurred and disincentivize the same thing from happening in the future. So in the former, when you're trying to prevent undue consolidation, and I agree and take the point that this is to be distinguished from a situation where a company creates an incredible product and has market power because no one can create a product that is as good as that company. That is a good thing. This is a situation where a company expands its market power through acquisitions. There, I think there is an important role to play to make it more difficult to consolidate market power through acquisitions. To give a sense of the state of play now, there are reporting requirements that go to the Federal Trade Commission, the U.S. Department of Justice. The only way that government enforcers can stop a merger that would harm competition is to make a decision to file a lawsuit to stop the case. And those decisions for agencies that are, have few resources, few people, that is an enormous decision. When you challenge a merger between two enormous companies, the meetings required for that decision, and then the resources required to put into that case that cannot be spent in other enforcement efforts is very, very real. And so, on the front end, I think creating rules of the road that allow challenges to be brought, I think, with less resources, perhaps. It's a tremendously complicated endeavor, tremendously costly for the enforcers. And then at the court level, to articulate standards to give courts more guidance. Because right now, it is essentially the product of common law. We're asking generalist judges some of, the vast majority of whom have no antitrust training, to hear from, to make a decision about whether to let a merger go through or not, and looking at things like the merger guidelines, which are, persuasive authority that we mentioned that were recently revised. And I think there can be work and progress in terms of providing statutory guidance and requirements to address things like market definition, market power that we've been talking about. So yeah, I'll stop there.
Other questions from commissioners?
Yeah, forgive me if this question isn't fair, because I understand the scope of your presentation and you may not have thought of answers to this. But as a practical matter, New York had legislative efforts as well. And since we're starting, do you have any advice or observations about the way New York approached this to the point where it couldn't get its legislation passed? You've done a great job at identifying problems. And now I see one of the issues for the commission is, how do we address those problems and not let the perfect be the enemy of the good? And so is there something we should be thinking about doing that New York, maybe in hindsight, didn't do, or any insights you could give to us? Because I'm sure the New York people had similar presentations about the anti-competitive things going on, and they probably earnestly wanted to fix those, but after years of work, nothing became of it.
And without amending Commissioner King's question, I'd like to ask a supplement, because I think the answer will cover both of our questions. I know that when we mobilized our working groups, we wanted you to provide a landscape rather than reach conclusions. So we know we didn't ask you to reach conclusions, but I'm curious, now that you've ranged freely over the landscape, is it your conclusion that what's needed is a major restructuring, or are there more limited fixes to address the problems using the existing framework that we have?
Those are,
But please start with Commissioner King's question.
Sure.
I think, Diana, do you want to address the New York question?
Sure, and I'm very happy to respond. I actually do not have a direct response for you. There have been a number of state level efforts, including New York. There have been federal bills that have proposed reforms to the antitrust laws. There is a robust debate that has been ongoing about the best approach and why things succeed, legislative efforts succeed or fail. This is something, commissioners, that we would very much like to give some more thought to in our group. You're right, we did not, we took our mandate seriously and we did not provide recommendations. Rather, we provided you substance and analysis upon which future recommendations could be evaluated. And but this is something we would like to talk about amongst our group. It's a big question. I think it's a nuanced question. So if we could beg for a little bit more time, we are happy to convene again and get you further thoughts.
And just to add to what Diana said, we did take very seriously the mandate and your request of us to simply lay out the landscape and not put on our advocate's hat as people that have been in court for the past 2 decades and tell you what we would do were we in your shoes. But certainly, I know Dean and I have had many conversations about this. We would gladly welcome the ability to give you a couple of our thoughts and more specific on this point, because certainly spending, I think it's been the better part of a year with this working group and talking about these issues on a very regular basis and putting together this report and trying to be as helpful as we could for you. I know that we all had a lot of thoughts about what we would say in the final chapter that we weren't allowed to write of the report, which is what we think could help make this a better place.
If I could just add one thing very briefly, I'm speaking again just about the hospital sector, but I think what I'm about to say applies to other sectors also. There's been a lot of evidence to suggest that hospital mergers have been allowed in spite of exceeding the antitrust law's threshold. That is, if there were proper enforcement, these mergers would have been prohibited. That suggests that there's no significant change in law that's necessary. just some additional enforcement. And there are a number of states, the Federal Trade Commission has primary responsibility for this anti-merger or merger policing enforcement, but there are a number of states that have invested resources. States certainly can participate. They're not precluded by federal law. And some of those interventions that states have pursued have been simply another layer of review that's required by the state attorney general's office. In fact, actually, a lot of that already can happen under current California law. So this is, in spite of the huge problem, you might say that there's a fairly easy solution that doesn't require any change in law.
So I just want to chime in here really quickly because I would second what Barak has just said. And this goes back to the earlier question about how do you link up the micro with the macro, which is really a very, very good, important question. And you're absolutely right. Antitrust enforcement, state level, private, public, federal, private, really does look at things as they come. A deal, a proposed merger, an alleged form of anti-competitive conduct. As an economist, we are studying the linkages or not linkages between how antitrust enforcement case selection occurs in these smaller markets, more narrowly defined markets in which antitrust enforcement occurs, and bigger sectors in the economy. And I am actually right now in the middle of a study that does that. We would like to see more connection or relationship between case selection in the antitrust world and what is happening in sectors more broadly, which sectors are becoming more concentrated, which sectors are highly concentrated. And, antitrust enforcers don't pay a lot of attention to whether a sector has grown more concentrated, for example, over a 10 to 15 or 20-year period. That is an important, I think, policy implication in part to answer your question, to try and link up the micro with the macro in a little better than it has been so far. But what Barak is saying is we need more vigorous enforcement. That is a major outgrowth from the analysis that we have done. Not necessarily a change in the law, but for sure more vigorous, stronger enforcement to protect our markets.
Thank you. I believe our intention was to do the two panels back to back so that we got them done. Would it be the pleasure of the commissioners to take a 10-minute break while the switch is being accomplished? Okay, let's be back at 10 after the hour. And again, thank you to our first panel for all the work you've put into this.
Yeah.